Heath Grossman here with Money Wisdom Question Series. Today's question is in regards to estate planning. Specifically, what documents does someone need if they want to do some estate planning? So there's three main documents that we suggest having if you're going to undergo preparing an estate plan. Number one is a will. You need to have a will. Many people say, well, I don't necessarily need a will. Everything I have has a beneficiary or maybe a joint owner. Well, be that as it may, but we do suggest having a will. If you pass away without a will, it's called dying intestate. And then the state that you live in has to decide where your money goes to. It's going to be a much simpler and easier process if you have a will. Another document that we suggest having is a living will. A living will doesn't necessarily concern the assets that you have, but more of from a healthcare standpoint. What are the instances where you do or do not want to have extraordinary measures taken to possibly keep you alive? Or who would be the person to make decisions on your behalf if you were incapacitated and could not make those decisions on your own? The third document that we suggest having is a durable power of attorney, right? This could be very important. What a power of attorney does is it designates someone, most often a spouse, that could essentially act on your behalf and sign your name in place of you and essentially make decisions for you. We also suggest it being durable, meaning that even if you become incapacitated at some point in the future, that power of attorney is still valid and can still be used. There are measures that possibly need to be taken down the road if someone's incapacitated from an estate planning standpoint or a Medicaid planning standpoint, where you need to have that durable power of attorney in place ahead of time. And if you don't have it, you can't go ahead and get it at that point, and maybe some of the measures that you could possibly take at that point are essentially off the table. Now, beyond having a will, we oftentimes get people ask us and say, well, should I be, doing a trust, right? And where could that make sense? It's going to depend on the situation. A trust essentially, most often a trust is going to give you some type of control from beyond the grave of the assets, if you desire to have that. Maybe you have an adult child that you certainly want to give the assets to, but you don't have confidence that that person would make the right decisions with the money, and you would want to control the money from beyond the grave. That could be a reason to possibly have a trust. Maybe you have property in multiple states. So instead of going to probate within all of the states that you have property, you might want to own those properties within a trust. So it's just a little bit simpler and easier. And beyond that, there could be other more extensive reasons to possibly have a trust.